in Batts. So Amos Tyndall was the guardian ad litem. Cheval Batts was a young man that was paralyzed by a lap belt. Case against Ford. I'm going to run through the preliminaries very quickly. This is Cheval, 11 at the time of the accident, 16 at the time of trial. And great kid, wonderful. He was from a very poor family in Nash County, North Carolina. It is east of Raleigh, about an hour. It's a small rural county. The makeup of the county is about 2/3 white, 1/3 African American. So that's the location. Great client, very good student, had aspirations to go to college, will go to college. Amos Tyndall was his guardian ad litem. I worked very closely with him, a lawyer in Raleigh, and was good to work with. I had co-counsel Hoyt Tesner, brilliant, great trial lawyer in North Carolina. He and I tried the case together. This is the accident scene. Nothing important about this other than rural road, Jeep makes an improper left turn, and the Ford Escort that Cheval was riding in hit the Jeep. This is the Ford Escort. So when I looked at this, it's a serious crash, but it's not one where somebody should have been paralyzed. And what was more important, there were 5 people in this Escort. It's a 1999 Escort. There were some broken bones, but Cheval was in the rear middle seat, rear center seat. It's the only one that had a lap belt. Guess what? He's paralyzed. His brother right next to him had a 3-point lap shoulder belt. He walks away. It doesn't take a rocket scientist to figure out this was a defect. The lap belt was a defect. And so this was a Jeep. The Jeep driver walked away. We had the Jeep driver in the case. His name is Rios. This is the defect of a lap belt. It jackknifes over the lap belt. And this defect's been around a long time. Guess what? Car manufacturers had settled these cases for years. I don't think one of these cases have been tried in the 10 years before I got this case. Now, Ford decided they weren't going to offer any money in this case. Ford took us to the North Carolina Supreme Court on a statute of repose issue. So this case took years to get to trial because of the appellate delay, and we were able to succeed there. But it's one that Ford decided they were going to try this case no matter what. They gave us no true opportunity to settle the case. So we get into it, and I'm going to talk about the opening statement here. One thing I want to go over with respect to opening statement, I'm trying to catch up some time here, but the focus group in this case told us that we had to carefully explain crashworthy, what it means and why it's important. It told us that we had to explain enhanced injury or increased injury to an occupant. It told us that we need to talk about cost, that juries weren't going to say car manufacturers had to put in a safety feature regardless of cost. You had to show them that it was a reasonable cost. And you had to talk about the other driver and why manufacturers are responsible no matter who caused the crash. So I ran through that pretty quickly, but with Artemis's help and the focus groups, and she helped me a lot with regard to opening statement. Those were the points I was trying to convey. I'm going to stop sharing my screen, and Lori is going to play the clip. And this is at the beginning of my opening statement where this clip comes from. And CDN has the entire trial available.
A manufacturer is never allowed to unnecessarily put the public at risk. Car manufacturers must build cars that are crashworthy. Now, crashworthy means that every part of every car is designed and built safely enough to keep passengers as safe as possible in a crash. That's an important word. I'm going to say that one more time. Crashworthy is a pretty simple, straightforward concept. It means that every part of every car is safe enough that in the event of a crash, that the passengers are kept as safe as possible. That's what crashworthy means. Manufacturers are required to make every part of every car crashworthy. Now, it has to be as crashworthy as technology allows and without costing the manufacturer an unreasonable amount of money. So every part has to be crashworthy as technology allows without costing the manufacturer an unreasonable amount of money. We're going to be talking a lot in this case about extra harm or extra injuries. Now, what does that mean? It's when people are harmed more than they would have been in a crash if the part had been made crashworthy. I'm going to say that a little bit differently because this is not a common term. Extra harm or extra injuries is when there's a crash and some part of the car is not crashworthy. And because of that, a passenger is injured more than they would have been if it had been manufactured crashworthy. That's the extra harm. The extra injuries, sometimes it's called enhanced injuries. That's what the manufacturer is responsible for. When is a manufacturer responsible for these extra harm or extra injuries? It's when the part could have been made safer. Again, without costing the manufacturer an unreasonable amount of money, no matter who caused the crash. So it doesn't matter who caused the crash. If the manufacturer made a part that was not crashworthy and somebody has these extra harm, causes extra harm or extra injuries, that's what the manufacturer is responsible for.